that is determine the applicability of GDPR and the status of the party. So, do you sell goods or services to EU business consumers or both? To the person from EU or UK also, because I just took UK because it is an adequate country. I'm sorry for that. So UK is an adequate country, right? So do the persons from European Union or UK visit your website? Do you sell your goods or services in UK? Do you have employees in EU or UK? UK is an adequate country. Do you monitor the behavior of persons within EU? So all these cases there you have the GDPR, the applicability of the GDPR. In the first session, we had talked about the material and the territorial applicability of GDPR. That is what you have to assess. And it is only when you have assessed that the GDPR applies, we come to the real game of, creating these impact assessment documents and data processing documents and things like that. So creating a data map through this action, what do you really do? First, you document the retention periods in the system. Then you determine whether you store, collect, process any special category of data, whether you have racial or ethnic origins of data, whether you have genetic data, whether you have political data, so biometric data, religious data, data related to health, sex life or sexual orientation, trade union membership data. So this is how you create a data map. What is a data map? It is mapping, that what kind of data do you have, and data mapping is very commonly used in a corporate world, and for me it sounds like quite a fancy word, but this is what you do when you map. When you just identify what is the nature of data that you're processing and what kind of data you're processing, that's mapping your data in this case. And document. See, documenting is really important. That is, what is the database or the application, who is the vendor which stores data or processes data based, where is the vendor based, all that. So that's how you map the data, and you write about where is the data stored, who has access to data, what category of data do we have, are there special categories of data. So this is the second step when you do a transfer impact analysis. Then create a data map by taking the following actions. So what do you do first? Determine whether your data map meets the requirement of records of processing under Article 30. So, when you have the records of processing in an organization, which is quite important these days for all the organizations based in European Union, you have to ensure that your data, an organization uses lots of applications, right? Those applications can be for storing data, for giving analytical results. Then how you have to ensure that these applications that they're used, how do they store your data? Whether it is, the name and the contract, the purpose behind it, the description of categories, who will receive the data. Then determining whether your data mapping includes informations like names and details of the processor or the sub-processors, the categories of data which the processor is processing on behalf of the controller, documentation of suitable safeguards of data transfer to a third country. Have you conducted your transfer impact assessment? Has there been organizational and technical measures? And then a general description of everything. That has to be mapped. That it talks about what is necessary for compliance, what are your legal basis of transferring data and things. Just a second. Yeah. So did you take consent? Was there any other way? Is it contractual obligation? How are you processing the data? And what is necessary for compliance with legal obligation? What is necessary in order to protect vital interest? Cisco contract was not about vital interest for sure. So necessary for compliance of task, and what is the ground for processing your personal data? We've read about the ground for processing personal data, that should be there. Then determine the following. What are the organizational technical measures? Who has access to data? Is there multi-factor authentication? Is the data encrypted? If yes, where are the keys? Who can access the keys? Is the data pseudonymized? What is the measures related to data protection by design? For example, if my organization is deciding to be data compliant from today and they're building a project about it, that we have to ensure that the records of processing are in place and everything is maintained. Retention and deletion works well, that some data is automatically deleted, manual deleting happens at regular intervals, and we cannot store data or beyond this time, all that. So is that there? Or if it is not there, then how can we incorporate data protection in something that's already developed? Then that will be data protection by default, that you're bringing something into it. And that's what you discussed about. A little about data protection by design, because I know it can be confusing if you are not working in a corporate and if you have not worked with data protection by design, it can be confusing. It was confusing for me for a very, very long time. So if you find it difficult and confusing, don't beat yourself about it. So it means, embedding data privacy features and data privacy enhancing technologies directly into the design of the project at a very early stage. For example, I'll just give you an example. An organization X suddenly feels that it has been retaining data for a very long time and it is not being deleting data. And it could falter under GDPR compliance of retention and deletion. So the organization decides to build up a policy on retention and deletion and ensure that let's be compliant now. Let's take X to be a banking organization. It has lots of consumer data and lots of consumers who have exited the bank also, who are no more, they might have taken a loan from the bank and they paid their loan and now they're not with the bank. People who might have closed their account with this bank and gone on to another bank. So does the bank have their data? Why does the bank have their data? Where is the data stored? When can this data be accessed? So when they're building a project on retention and deletion, they start talking around these lines. That what are the categories of data we are storing? Where is it stored? On what grounds are we storing the data? Have we taken the permission? Because storing of data is processing of data. Have we taken the permission for processing data in this way? When can we delete this data? How can we delete this data? Will all this data go into an engine, a central system where it is deleted automatically, or where there will be manual deletion of data? What are unstructured data? What is structured data in the organization? Differentiating among them. And, building mechanisms and giving trainings to staff and employees to delete data, which is on their laptops, which is on their desktops, which is probably on their phones, things like that. So this is data protection by design, and having this in your transfer impact assessment is quite important.